Hi, everybody. If you could all take your seats, we're going to get started in a second. Thanks. I hope everybody's helped themselves to food. Well, good afternoon, everyone. My name is Judy Applebaum, and I am the Director of Programs at the American Constitution Society. And on behalf of ACS, I want to welcome everyone here. I want to thank our terrific panelists for joining us at this event. And first of all, a quick word about ACS for those of you who may not be familiar with us. ACS is a national organization of lawyers, legal scholars, law students, policymakers, and others working to advance a progressive vision of the Constitution, law, and public policy. And as part of that mission, among many other things, we organize briefings like this on important policy issues, including Capitol Hill briefings, briefings at the National Press Club, and elsewhere. ACS itself doesn't take positions pro or con on legislative proposals, and the views of the speakers are theirs alone. But we think it's important to present a variety of views and perspectives on important issues like the one before us today on the Convention on the Elimination of Race Discrimination, or CERD. If you would like to learn more about ACS, or even better, join ACS, you can go to our website, www.acslaw.org, and sign up. And with membership, you will get all the notices of events like this. You will get our regular e-bulletin. You'll get complimentary subscriptions to our 2 journals and many other things. So I encourage you to look into that. A small housekeeping matter, we are filming this for our website, not live, but it will be posted on our website. And so I would ask that you turn off cell phones. And we would also ask that you keep any questions to the end. Our panelists have promised to allow plenty of time for questions, and we have microphones situated around the room for that. So hold your questions and you'll get a chance. With that, I want to tell you a little bit about our moderator, Lisa Crooms, and then I will turn it over to her to introduce the other speakers and to start the discussion. Professor Crooms teaches constitutional law, international law, and other subjects at Howard University Law School. She serves on the boards of a number of human rights organizations, and she's been an advisor to many organizations, including the Urban Justice Center, UNIFEM, the Sentencing Project, Global Rights, and Amnesty International USA. She also was the coordinator of the 2007 U.S. Coordinated NGO, or Non-Governmental Organization, Shadow Report to the UN CERD Committee. And like several of the panelists, Professor Crooms participated in the proceedings before the CERD Committee this year in Geneva, Switzerland. She, like every one of the panelists, brings tremendous expertise to this subject. So, Lisa, why don't you take it from here? Thank you all.
I'll start here. Thank you, Judy. Good afternoon. Hopefully lunch is good. And, you know, the substance will be as good as the food. But today we're here to talk about the Convention on Racial Discrimination. What does it mean for U.S. policy? And I've been given a couple of tasks. One is to set quite briefly sort of a context for those of you all who are coming to the table and have no idea even what that acronym CERD stands for. And it would be CERD, not SERD, just in case you're absolutely new to this. Second is to introduce you to my most esteemed colleagues seated to my right. And third is to hopefully moderate by way of questions posed to my colleagues up here, an interesting conversation that should then serve as a good jumping off point for a little broader engagement. So hopefully we'll be able to seed you all with some interesting ideas, which will then generate some provocative, at the very least, questions about what we've all come to talk about today. So, by way of context, the easiest way to do this is just bear with me. I'm a constitutional law professor. Article 6 of the Constitution contains something called the Supremacy Clause. The Supremacy Clause states that among the supreme laws of the land are to be found treaties, duly ratified. Now, most of us, when we think about treaties, we think about agreements that apply externally. primarily a matter of foreign affairs, international relations. NAFTA might come to mind, a little bit of a hybrid, but basically it's about things that happen elsewhere. The treaties that CERD is a part of are different types of treaties. While they still remain agreements between countries, the treaties that we're here to talk about are treaties that give rise to obligations for the country signing the treaty in terms of how it treats its own citizens. So while the instrument itself may fall within the sort of traditional framework of international relations, the substance of the treaty is necessarily domestic. So that's part of the reason why many of you all find yourselves here, because it's a way to talk about our international obligations, because what's called the International Convention on the Elimination of All Forms of Racial Discrimination, so now you understand why we refer to it as CERD, right, was in fact ratified by the United States government in 1994. Now, it was open to signature in 1966. So you can contemplate the number of years between us being in a position to sign it and when we actually signed and ratified it. In 2001, the United States, according to the terms of the treaty, you have to report on your compliance periodically. 2001 is the first time the United States files a compliance report. And the process not only contemplates the state being involved, but non-governmental organizations having a role to play in terms of putting out there on the table by way of what's called shadow reports and additional opportunities to engage in advocacy, providing the committee members with perhaps a different spin on what might be commonly agreed upon facts that the government might have in fact included in its report. Fast forward 7 years later, the United States reports again. That brings us to 2008. And what Judy referred to in her opening remarks, a number of us sitting up here, in fact, participated in a highly coordinated, some might say controlled, effort that brought together at some level in terms of drafting and signing on to more than 400 organizations and individuals, in terms of people on the ground in Geneva engaged in advocacy, somewhere between 125 and 130 US-based advocates, to participate in the compliance review that the United States government was subject to under the terms of the treaty. So it's sort of on the heels of that compliance review in February that we find ourselves here. Because needless to say, some folks are particularly interested in a mechanism that they knew nothing about prior to February. And some of us who might have known about it may in fact be either a little more skeptical about its usefulness or a little more energized about the opportunity, multiple opportunities that might present themselves in light of our experiences in Geneva. So today, we're here with folks, in fact, embracing a range of views to try and facilitate a conversation. So where I want to start, and I pose this question to, whoops, my bad, all right. This sheet of paper, these are the bios, right? I'm going to introduce these people, but I'm assuming everyone can read, hence I'm not reading the entire thing. I've let people know, it's not that I don't find everything that you did to be really important and interesting, but I'm limiting it to what you do right now. And for those who want further background, I would suggest that you look at the sheet. So starting with my far right, which is very rare, would be Ajamu S. Baraka, who is the executive director of the U.S. Human Rights Network. And that's a network that serves more than 250 U.S.-based member organizations working on the full spectrum of human rights issues. Next in line would be our new friend, Stephen Groves. He's a fellow at the Margaret Thatcher Center for Freedom at the Heritage Foundation. And in that capacity, he's responsible for developing and running the Freedom Project, which has a goal to advance Anglo-American leadership on global freedom issues, including international political and religious freedom, the strengthening of democratic institutions, and human rights. Next in line would be Marcia Johnson Blanco, senior counsel from the Lawyers Committee for Civil Rights Under Law, and specifically in the Voting Rights Project of the Lawyers Committee. And one of her core responsibilities in this capacity is working on issues related to the reauthorization of the Voting Rights Act, which included the organization and administration of the National Commission of the Voting Rights Act, on which she serves as the deputy director. And last but not least would be Jamil Dakwar, who is the director of the Human Rights Program at the American Civil Liberties Union. And he, at this point in time, on top of all of the rest of the things he has to do, he's one of a team of ACLU lawyers litigating Ali versus Rumsfeld, a suit challenging U.S. interrogation and detention practices in Afghanistan and Iraq. So, having said that, my first question, open to all of you, is the following. Is ratifying treaties such as CERD beneficial or harmful to the U.S. and our rights as a sovereign nation? That's to start with just a softball. We can go in the order that I introduced you.
The UN. Yes, I will. I guess I'll start off. I think that, of course, it benefits us as a nation. If we remind ourselves of the standing of this country regarding human rights, notions of freedom, democracy, a commitment to the rule of law, and we remind ourselves further that CERD is one of those instruments that was produced coming out of the international community, an instrument in which the U.S. was involved in helping to construct. If we remind ourselves further that the very structure of the UN was a organization that the U.S. government was very much in support of, helped to put into place, and that the human rights documents that served as the foundation for the human rights ideal, including the Universal Declaration of Human Rights, was something that the U.S. was deeply involved in. Then there's something there that's consistent that suggests that this country should embrace this document, that this is a document that reflects a commitment to international law, an international sense of morality, and that not only should the country embrace it, but it should champion this document, this instrument, and all of the other instruments that make up the human rights regime. So it's very difficult for the U.S. to claim to be a defender and champion of human rights without being in the forefront of advancing knowledge domestically on this instrument and demonstrating to the international community its commitment to this instrument and all of the other instruments that make up the human rights framework.
Thank you, Lisa, and thank you, Judy, and the American Constitution Society for inviting me to come. There's always a temptation to not invite someone who has a skeptical view of the thing you're going to be talking about, so I appreciate the invitation and the chance to talk about these issues with you guys, these issues with you guys today. And I am skeptical of CERD and whether it really advances the causes that we up here in the panel care about, and everyone in the room, I'm sure, cares about. But I think maybe it's too early to make to give a verdict on whether, in the long run, our participation in this treaty is going to be beneficial to us. To answer your question more directly, I think we have a pretty limited record with just the 2001 and the 2008 submission to determine whether or not this is going to be a constructive vehicle for addressing race relations in America. I will say that so far what we have seen from the CERD committee, which is the body of international experts that reports and gives recommendations about state of race relations and racial discrimination in America that I'm not very sanguine about the future for this committee, only because it boils down to 18 international experts from around the world attempting to pass judgment and make recommendations about extremely complex issues dealing with race relations here in the United States. You need only follow the recent brouhaha over Reverend Wright's remarks to see how complex these issues are to the social fabric of the United States. And to line up 18 people sitting over in Geneva, many of whom didn't grow up, I would say the vast majority of whom did not grow up or were educated or live in the United States, and maybe some of them never even traveled to the United States, and have them opine on issues that go to the core of our nation's history and traditions and the legacy of slavery and racial discrimination that we have to deal with as a people. I find it difficult to believe that their opinions on these matters are going to be very persuasive, and that's why I'm skeptical.
Good afternoon, everyone. I'm very happy to be here this afternoon. To answer Lisa's question, I think that the CERD is very beneficial, surprise, surprise. The reason why I think so is because it really energizes the work that we do as civil rights attorneys at the Lawyers Committee and others of you who are in the room and on the panel, because it broadens the framework under which we look at our issues. We're looking at it as a human rights agenda, more so than a narrow nationalistic agenda. We're looking at what are basic rights that are attributable to us as human beings. This framework that we're looking at is a framework not just of the legal, but also of the moral, and what obligations do we have to provide equality for everyone across the board. And as someone who works in civil rights organizations, we are of course cognizant that we've passed some fantastic laws in this country that have done a lot to raise the bar and move our country forward. But has it moved us forward enough? Are we at a place where we can say that there are no disparities? Are we at a level of disparities that we think are acceptable? And I would say that we are not. I would say that our laws have taken us to a certain point, but what a convention like CERD does, and looking at our issues from a broader perspective and a broader framework, is that it gives us a broader tool, a broader language at which to address the issues that we all care so much about.
I want to join in thanking ACS for organizing this, and I see a lot of colleagues and people with good faces and people who worked very hard on this in the past year or so. So I want to, I think, try not to repeat the things that some of my colleagues mentioned. I think the CERD is, there's a historical, of course, context to why the U.S. has signed and subsequently ratified the treaty, and why the U.S. was late in joining the international community in this important international convention. And it's, it's the, legacy of slavery, but it's also legacy of, Jim Crow and lynching and segregation in this country. And it was important in the time when it was signed by President Johnson to make a very important statement, I think. And it came in the heels of the civil rights movement. But the problem was that it was left only as a statement and not as an act that of commitment that would be followed by implementation, enforcement on the ground, and not looking at U.S. issues as isolated from the world in general. I think the tendency is always to see that the U.S. is endorsing the human rights framework, endorsing CERD and other international treaties in its foreign policy when it comes to other countries. You can see that very clearly from the State Department human rights reports issued every year in March. But when it comes to the U.S. record on human rights, unfortunately, we are in a much weaker situation because not only that the treaties have not been fully implemented and enforced, there has been an attempt to cut down or to redefine the intent, the very intent of this treaty. And one example is the definition of racial discrimination in this convention, which tries to combat racial discrimination, not only those acts that are in purpose, but also the effect of acts that have on racial and ethnic minorities. So the purpose or effect test has been almost universally recognized and accepted by the entire world, and yet the U.S. has its own reservation on only intentional discrimination, only when we have an overt acts of discrimination that the government will provide remedy and will act. And I think that has something that we have to think about. And CERD obviously provides us with the tool to address those situations where intentional discrimination, and unfortunately the most recent forms of discrimination are not always intentional discrimination. It's about things that happen because of certain policies that not necessarily on their face directed at one particular ethnic or racial minority, but rather their effect has a devastating consequences.
All righty. Well, that was an interesting opening round. And I'm torn between, well, I think the next question I want to ask is, because Jamu and Steve in particular talked about different sort of aspects of U.S. participation, whether it be as a matter of historical sort of leadership and the idea of grappling with exceptionalism, or whether it be, for example, as a reporting country, appearing before the committee. But I'm wondering, because the U.S. plays a dual role. That is, we're not only party to the treaty, we are in fact a member of the committee. So I'm wondering how, if either one of you care to comment on, let's say, the interrelatedness of these two roles and whether the U.S. conduct as it relates to one of its roles may in fact affect, whether it be adversely or otherwise, its ability to assume its other role as it relates to still this particular treaty.
Well, if I understand the question, it's whether there's an inherent or some type of conflict between our role as a reporting nation and the fact that we have a U.S. representative as one of the panel of experts?
No. Oh. Sorry, no, to restate the question, it would be, would our performance, let's say, as a reporting country, under what circumstances would our performance as a reporting country undermine our ability, quite honestly, to sit as a member of the committee? And if there is something to be gained from us fully reporting in light of the role that we play as a committee member, and the notion that we have grappled with these issues in this country in a particular way, and perhaps we do have something to bring to the table in terms of the international discourse around race that takes place within the confines of this committee's process.
Well, I'd only be able to comment on in a fairly limited capacity without having read the reports that were written about other countries. I've only read a limited number that don't relate to the United States. But obviously, if we're a member of the treaty, which we are, we should fully report. It's a treaty that's been signed and ratified, so we have to fully report under our treaty obligations. And in terms of participation, there should be no problem with continuing to push to allow U.S. members to be delegates of the experts committee. Whether or not our participation as a member of the expert committee will do a great deal for the rest of the world in terms of their race discrimination records, I think falls a lot on who that expert is and how active they are. But I think they're two mutually exclusive things. I believe the treaty obligations are one thing, and whether to participate in the process of being an expert is another.
Yeah, I think what's really more important is the fact that it's clear to the international community that the U.S. is participating, that it is attempting to meet its treaty obligations. Again, if the U.S. is going to proclaim itself as a champion of human rights, it's important that for those treaties that the U.S. has signed and ratified, that it live up to its treaty obligations. So having an expert on the committee is important. I also think it's important for the U.S. to be involved in the other human rights related committees at the UN. You know, the U.S. cannot have it both ways. You cannot pretend to be a champion, a defender of human rights, while at the same time avoiding your responsibilities under the treaties that you may have signed, and avoiding your responsibilities to provide leadership through example to the international community. But we've seen that, in particular over the last, 8 years and more, that there's been an attempt to try to have it both ways. And so that's one of the reasons why we have to have a strong and effective domestic voice. Individuals, organizations committed to the idea of human rights, committed to the notion that there should be one standard for all, organized and in a position to basically demand accountability to our representatives, both domestically and internationally.
And I would say on the issue of participation, I want to just move it not just from the reporting or being on the expert committee, but also making sure that we meet our obligations under the treaty. Because the treaty does provide affirmative obligations that we have to meet. And when Jamil talked about the purpose and effect, I mean, one of the things that we're dealing with right now in our jurisprudence is, as he said, this narrow focus on is there purposeful discrimination, and this refusal to look at the disparate effects of our policy and the effect that the policy has on minority communities. And so we need to broaden the way we approach the treaty, I think, and not just focus on minimal obligations. I mean, we were in Geneva and we saw with the reporting, the U.S. reports, it fulfills its obligation to report, but in a very minimal way. It talks about the laws that we have on the books. We have great laws on the books, but how are these laws being implemented? How are they being interpreted? That is also part of the process and something that I think the U.S. needs to do more fully.
All right, but doesn't that leave those who want to use this forum open to the criticism that basically what you're relying upon is an undemocratic avenue to ultimately achieve what you were unable to achieve as using domestic institutions and mechanisms? So, for example, I mean, part of the reason why we've got the purpose and effect distinction that continues to sort of haunt our jurisprudence, as it were, is because, you know, Washington v. Davis, the court said you got to show, or go back to the civil rights cases, you know, but it's because we lost in the courts, right? That ultimately you're saying, okay, well, there's this other place over here that has a much broader definition, but doesn't that, in fact, go against our sort of fundamental democratic principles?
Well, what happens when we lose in the courts? No, we come back to this body. We come back to the Congress. And we say, okay, as a people, what obligations do we want to meet? How do we want to clarify what the court has seen? How do we want to interpret the court's narrow focus the court has on our obligations? I mean, this treaty is also part of our domestic law. It was ratified by a popularly elected body, and it is now part of our domestic obligation. And it is another framework with which we could look at the issues that come before us and say, how can we address the problems that we have in our society with disparate impacts on minorities? Do we just say, well, the court has spoken and throw our hands up? That's not our tradition. You know, we try to find ways to address issues and problems, and this is one way to go about doing so.
I think it's important, too, to follow up and say that and remind ourselves that when we talk about the human rights idea, we're talking about an idea that has two components. it has both a legal component and a moral component. And sometimes the legal aspect of it sort of lags behind sort of the moral ideals. So if we remind ourselves that the human rights ideals, the provisions are supposed to be sort of reflecting a minimal standard, a floor, if you will, in terms of rights protections. But as a consequence of U.S. practice over the last few decades, there's now a gap between U.S. domestic protections and what was a floor provided by the UN International Human Rights Structure. So we have a gap now that has to be filled. And so even though there may be some legal constraints in terms of our ability to access these treaties in the courts, they still provide, I believe, a normative framework, a moral framework that allows us to appeal to the authorities, allow us to organize ourselves and to educate the American people on the existence of these standards, and then to engage in a process of struggle in order to equalize the legal aspect and the moral aspect. So you have legal claims, you have moral claims that have to then be sort of codified as a consequence of struggle. So for me, the struggle in the 21st century is in fact the struggle for human rights. It is to close that gap. It is to bring the U.S. in compliance with what has been developed by the international community, with the full input of civil society from this country, and to move us forward in a very, very progressive way.
I just want to add another dimension, which is, if you look at CERD, it is, in addition to the issue of the purpose and effect, we have the way that those international treaties are trying to look at domestic issues, and they certainly are about making government look into their domestic laws, look into their domestic policies, and try to do better. And if you look at the different treaties, they try to address not only specific thematic issues, but also they are intersectional in the way that they are supposed to be implemented and enforced. So, for example, they look at gender perspectives and implications, how a particular policy is affecting women, how a particular policy is affecting minorities, how it is even affecting non-citizens. You have over 40 million people who are non-citizens in the United States. Green card holder, permanent residents, workers, guest workers, and also undocumented persons. And what happens to those people who are in the country? Once you are in the country, that's what the treaties, those human rights instruments, including CERD, you should be protected from minimum, should be protected under minimum standards, including protection from anti-discrimination. So the way that the U.S. government, unfortunately, approached its legal obligation was very formally, very, very narrowly defining its own obligations under the treaty, not looking at what it has to take into account not only the effects, but also how it really affecting particularly vulnerable communities in the country that do not have the strong voice in the democratic process. And that is a particular important point. It is true that those treaties have monitoring mechanism and independent experts, and they are not U.S. citizens. Only one of them is U.S. citizen. But no one forced the United States to enter into those treaties. Nobody had put a gun to, Secretary of State to bring this to the Senate to ratify it. So once you are part of this, and with all the reservations, and we do have as NGOs and advocates, we do have reservations on the way this and other treaties have been ratified, in the sense that they were cut down. They were not, there's many protections that were excluded. But that said, we still have so many other protections that have been not advised, not been looked at. And one of the things that we're hoping that this process is going to do is that we will come back here, and we are in Congress, to see how Congress could look at treaty obligations, take advice from what those mechanisms said. What are the best practices that came out of not only maybe this treaty body, but particularly of how the U.S. can do better on human rights. When you look at legislations, is there any human rights analysis and treaty obligations analysis. Unfortunately, the only thing that we heard in the past 7, 8 years was consulting treaty obligations when it comes to redefining torture. When we were looking at how the government could go around of carrying out its actions in the so-called war on terror, but not looking at those affirmative obligations. Even in a time, and that's one of the things that, by the way, the Committee on Elimination of Racial Discrimination looked at, was after 9/11, how people in this country who were suspected in relationship to terrorism were treated. The roundup of hundreds of Arab Muslims and South Asians, mainly in the New York area. And that was important because the treaty obligations mandate that the government has to respect human rights, even in a time where there's a public emergency situation. And that is important because if the government, the United States government, is going to go out and look at Burma and what is happening now in Burma, or is looking at situation in Lebanon, and is going to try to protect people in those very, very difficult situations, it will have more credibility, I think, to do so when it has done better domestically, and even in a time, the worst time of this nation.
Just a couple of quick points. One of the complications, or I would call it a danger, when you ratify a treaty like this is it brings your treaty obligations and the interpretation of those treaty obligations by a body of international experts in Geneva into conflict with your own constitutional tradition. So when we're up here talking about whether something should be, racial discrimination must be proved versus a disparate impact, the committee in Geneva thinks it should be a fairly low standard, that it should be, if you can prove a disparate impact of a piece of legislation or a particular governmental act, then you have racial discrimination that must be remedied. This issue has been litigated up and down our federal system and up to the U.S. Supreme Court on a couple of occasions now, and they've come down with their rulings on this, and the committee doesn't like their rulings on this on the issue. So now it's I guess it comes back to Congress whether the Congress should be asked to actively overrule the Supreme Court's judgment on an issue of disparate impact, a very finely litigated issue that's been going on for years here in the United States throughout our federal system. Also on something like hate speech. You know, the members of the experts committee in Geneva, I'll go out of my way to say that they don't have the same strong First Amendment rights and tradition as we do back in their countries. You have to remember that a third of the independent experts on the committee in Geneva are from countries that are not even free. They don't have, they have a very poor human rights record. Saudi Arabia, pardon me, not Saudi Arabia, but Egypt, Algeria, Russia, China, Pakistan, and Togo are 6 of the countries represented on the human rights panel. So what they know of First Amendment rights and how they should be enforced, you could probably fit into a thimble. So when they come and tell us that that you should outlaw all hate speech, then I think you should take that with a bit of skepticism. You know, we have the First Amendment here, and you know, there are types of hate speech that should be stopped when you're actively inciting someone to cause violence to somebody, but otherwise you're going to have some protections under the First Amendment. So their opinion conflicts with our constitutional tradition, and those are the types of conflicts that you get into when you ratify a treaty where there's going to be someone commenting on your internal social policies and your internal legal traditions.
All right, well, that's a nice segue to the next question, which would be sort of to back up and ask, is the UN generally, or CERD more specifically, even an appropriate place or site for any part of the discourse about racial justice in the United States? I mean, because it seems as if, you know, my colleagues here to my right, seated to my right, all of them have sort of put out there, at the very least, conflicting views about whether this is a matter. Everybody agrees that we've made some progress, true? Show of hands. I mean, kind of, we've made some progress. I mean, since 1608, you know, we made some progress, all right. We might not be where we should be as a country. So having everybody agree about those two matters, then the next question is, okay, where can we talk about this? Where can we, in fact, engage in the kind of discourse that may, in fact, lead us to some new and unexplored ideas about how it is we deal with what seems to be an intractable problem? I knew that that was wrong. But basically, is the UN an appropriate site for that kind of conversation, or is this a conversation that should, in fact, take place largely in rooms and halls just like this?
Well, I'll go first and allow my colleagues to disagree with me. But you know, any place where the issues are discussed in an open and free environment, I'm always welcome to hear about it. The UN has a mixed record on whether they're effective in these types of issues. I think it should be an internal debate among ourselves. It's something that's going on in our presidential race. It's something that people talk about. Senator Obama gave an invitation to the country to engage in a dialogue, a frank and open dialogue. Ultimately, at the end of the day, it will only be the people in this room and other Americans who solve these issues and move our races closer together and fully assimilate. We've seen progress throughout the years. Even during my lifetime, I saw you know, how the races were mixed or did not mix when I was in middle school and high school, and now I look back and look at where my nieces and nephews are going through the same schools, and I see a cooperation and friendships that never would have been around during the times that I was in high school. So a lot of this is going to be anecdotal, but I don't know whether the UN is going to be the best forum, and I'll leave the whole Durban conversation for another day because I think we could have a separate panel on it. But I think that when you had the world community decide to get together and have a conference down in Durban, South Africa, about racial discrimination and xenophobia, it turned out to be an absolute debacle by almost everyone's standards. And whether the CERD itself would be a good and constructive forum, I think it remains to be seen. I think there's a mixed record so far, and so far that their reports and recommendations about the United States I don't think are helpful to our conversation about race, because I think, as I laid out in my paper, copies are available outside, I don't see them engaging in the true issues that divide the races here, and instead I think it represents kind of a far left agenda items. There's just a list of items about death penalty in Guantanamo Bay and transnational corporations and things that don't immediately come to mind for me when I'm thinking about race relations in America. So again, I think it remains to be seen. I think the forums should continue to operate. I mean, we're a member of the treaty, but I think the UN's record in resolving some of these issues is mixed so far.
Yeah, I don't think the UN should be seen as a place, providing a magic bullet. I think that it's one forum that we use, and we use it because we have the opportunity to use it because the U.S. signed on to this treaty. And then it obligates the U.S. to report, and it opens up the U.S. To international scrutiny. Look, one of the things that's so revolutionary about this human rights ideal is that it helped to begin the process of breaking down these claims to sovereignty that nations were making in terms of their own internal treatment of their citizens. It created a new culture in which we can look into nations and we can comment on how individuals and groups are being treated. When the U.S. Signed on to these treaties, it said basically, international community, we're open. We are going to adhere to these ideals and principles, and we're going to abide by the notion that we should be subject to critique. So as a consequence, this becomes a legitimate forum to talk about these issues. Look, let me just read, I'm going to have to read this. When the U.S. signed on to CERD, it basically said that it was committed to condemn racial discrimination and to, quote, pursue by all appropriate means and without delay a policy of eliminating racial discrimination in all its forms and promoting understandings among our races. To implement this policy, the federal government committed to, quote, engage in no act or practice of racial discrimination and to prohibit and to bring to an end by all appropriate means racial discrimination by persons, groups, or organizations. But even more importantly, it committed to ensure, quote, ensure that all public authorities and public institutions, national and local, shall act in conformity with this obligation and to take effective measures to review governmental, national, and local policies and to amend, rescind, or nullify any laws and regulations which have the effect of creating or perpetuating racial discrimination wherever it exists. This is what the U.S. signed on to. This provides an obligation for conduct. Okay, this is not something that you just elect to do. This is part of your obligation. So as a consequence, this becomes a legitimate forum for discussion. And when those folks come together to look at the U.S. record, they're not looking at the U.S. record by themselves. As a matter of fact, when they looked at it back in February, it was 125 of us from the U.S. over there with them to help them to see the record the way it should be seen. And along with our physical presence, we submitted a number of shadow reports that dealt with all of the issues we felt were important for the committee to be exposed to, and all of the complexities were there to help these independent experts to have an understanding of the realities here in this country. So, while these individuals may have some issues within their own particular countries, the process is a process in which civil societies are in a position to ensure that a perspective coming from the people is present when there's this kind of examination. So this is not some type of external, disconnected, alienated group of folks who are attempting to impose their ideals and perspectives on the U.S. No, this is part of the process that the U.S. signed on to. Now, if we find that the U.S. record is wanting a little bit, then that's a problem we have to deal with internally. But our responsibility is to lay it out the way it is.
Let me just add one more thing. I think it's important to remind everyone that this reporting process of appearing before the committee has been taking place very, very rarely, I would say. I mean, the U.S., this is the second appearance of the U.S. government before this committee, and it also made the second appearance before the other two committees. And it's on an average of maybe every 5, 6, 7 years. It doesn't happen every day. But the truth of the matter is that the consequences of violating and not committing itself to the treaties are felt every day. So I think what we're trying to engage is not a one-time thing. And I think the U.S. government took the hearings in Geneva very seriously. They sent a delegation headed by no other than Grace Chung Becker, who you all know is now going through a difficult time. But it has something to do with the commitment. 26 members of the U.S. government, including Department of Justice, Department of Defense, Department of Homeland Security, other agencies. For the first time, we had a representative from the state of Illinois. And this is something that I hope we will be able to talk about, is the fact that those treaties are not only addressed to the federal government in the sense that the federal government is the kind of the liaison between the country and the international community and the Geneva Committee, but it really addresses issues that has to do with implementation on the both national, local, and state level. And I think that's been very important. We noticed from the U.S. government report, for example, that there were only 4 states highlighted in an appendix attached to the main report. And the states were picked up were, I don't know exactly, we haven't really got a chance to understand why only those 4 states were particularly highlighted. New Mexico, state of Illinois, South Carolina, and Oregon. And, excluding states like California and Texas and Florida, New York, with much more diverse population and certainly with more complex and difficult racial discrimination problems, I think that has showed something about it. And I think, I think the approach, if we follow your approach, it is more unilateral approach that, we have to meet our obligations every 4 or 5 years, and then we come back home and nothing happens because, we just signed this treaty, doesn't mean anything. But I think the unilateral approach has been not good to us, and in the sense that there has been a lot of people who are saying, the U.S. in doing not only its international affairs, but also when consulting on issues, can you, again, in those times, ignore what's happening in the world? I think if I paraphrase, Justice O'Connor said, we can't anymore ignore the rest of the world when she was talking about some of the situations of human rights standards in other countries. Other justices in certain situations, looked at the execution of juveniles. And I want to close with this example of the way that the U.S. government, and particularly because of the Supreme Court, had basically stopped executing juveniles. When it appeared before the Human Rights Committee in 2006, the Human Rights Committee is the monitoring mechanism under the International Covenant on Civil and Political Rights, another important human rights treaty signed and ratified by the U.S. in 1992, ratified in 1992. When the government was asked about the executions of juveniles, why have you entered a reservation at the time of ratifying the treaty? And now that you have the Supreme Court as a matter of the law in this land, that you no longer can execute juvenile, why not to withdraw this reservation to the treaty? It was no comment. The government has not decided yet or to withdraw from this treaty. That's the kind of development, that's the kind of positive thing that we want to see. If there is some positive development, it has to be reflected in treaty obligations, not to leave it as a dry obligation on the papers. And I think that's where we would like to move this process of engaging with different parts of governments about treaty obligations. Hopefully in the near future there will be some considerable attention given to other international human rights treaties that will be also important for the U.S. to ratify. But this all starts with the genuine and commitment to move the concept of protections and rights to people, and not to always confine it to historical moment. Nothing changed since the adoption of the Constitutional Bill of Rights. And that's something that we would really like to see moving. And most of the acts, most of the pieces of legislation, I think, take into account those kind of developments, looking at what's happening in the country. And so the treaty obligation is just another layer. And certainly for the ACLU, our main struggles are, in court, here before Congress, and on the state and local level. But we realize that it is important for us also to look at what the government has committed to under international law, and to hold the government accountable for its human rights commitments is very important as part of the democratic process.
Okay. One thing I want to do before we turn specifically to matters that might be way more interesting to you all at the end of this, that being sort of like the concrete ask as it relates to what it is that Congress can do. I wanted to ask a question about the appropriate scope of the convention, and specifically, what are we talking about when we talk about racial discrimination? There are views represented up here that range from, if there is a disparity, no matter how slight the disparity might be, racial that is, that even if you're talking about a facially neutral measure with no apparent evidence of malevolence on the part of the person enacting the legislation, that any disparity raises an issue of racial discrimination. to the other end of the spectrum, that being absent evidence of that malevolence, that intent to discriminate on the basis of race, that disparities, no matter how stark they might be, will not by themselves give rise to, or should not by themselves give rise to, a legitimate or cognizable claim of racial discrimination. I'm interested in part because, I mean, Jamil raised questions about executing individuals who committed their death-eligible crimes, I guess, while they were juveniles. But there's also widespread racial disparities throughout the criminal legal system. And if you look specifically, let's say, at sentencing, in the areas of the death penalty, for example, and juvenile life without parole as being another example, just wondering, you know, are those things even properly before, or should they be properly before the committee? Are they racial discrimination as contemplated by the treaty, or are they racial discrimination as contemplated by the United States, you know, prior to it having ratified the treaty, so the U.S. takes with it its own understanding of what amounts to racial discrimination?
Well, I can go first again and be the whipping boy. Happy to do that. Obviously, I'm on the, again, the side of the issue where as well-meaning as the committee is and as well-meaning as the NGOs who are providing their shadow reports to the committee are, I believe that their results are part of an agenda not necessarily always tied to race relations questions. And I think that the report from the CERD committee speaks for itself in that regard. And I think these questions about the death penalty and incarceration rates fall squarely into the report as examples of that. The thinking is that, you know, minorities constitute a larger percentage on death row than they do in the population. Therefore, there must be racial discrimination in our death penalty system. Minorities account for a higher percentage of incarcerated individuals than the majority population. So there must obviously be racism rampant throughout our justice system, from the judges to the prosecutors to the juries and so forth. So their solutions to this tend to be on the left side of the agenda. Their solutions are, okay, well, end the death penalty, end sentences of life without the possibility of parole for people who committed their crimes under 18. The examples are listed throughout the CERD committee report, and so my skepticism is that that they don't necessarily care about the status of minorities on our death row or in our prisons, but rather they care about advancing an agenda that otherwise could not be advanced democratically in this country, where 68% of Americans believe that the death penalty is a proper punishment. Well, the United Nations and the CERD committee is pretty clear that they are not in favor of the death penalty. So if they can find a reason in their particular venue to recommend the abolition of the death penalty, they will. And I've just named a couple of examples. The other examples are listed throughout my paper, but don't believe my paper. Go read the CERD report. Copies are available. And judge for yourself whether there's an agenda behind the recommendations and comments made by the CERD committee, or judge whether they're really, really interested in advancing, ending racial discrimination in our country and advancing race relations.
Just in the direct response to this, I want to direct people to the paragraph 23 of the concluding observations from the committee, and copies are outside. And I really want to understand what's wrong with that, and in what way it is a leftist agenda when the ABA is cited in the recommendation. The committee remains concerned about the persistent and significant racial disparities with regard to the imposition of the death penalty, particularly those associated with the race of the victim, as evidenced by a number of studies, including a recent study released in October 2007 by the American Bar Association. So this is not a creation of the committee. It did not find this in Togo. it has found it in research and studies, and I think we saw another study that just was released, was in the New York Times a week or 10 days ago, that looked at cases of the death penalty, imposition of the death penalty in Texas, and how the racial disparities are still pervasive. And I think that what the committee looked at. It's true that the committee also called on the U.S. to consider a moratorium on the death penalty. I think this is something that is been generally said worldwide. The General Assembly of the United Nations last December has had a call on moratorium to all countries. And in that regard, I think, we have to just deal with it as was discussed. It was discussed in a very thorough, based on information that was provided by civil society, by the U.S. government, and the committee reached those conclusions based on its analysis of what are the standards regarding to racial discrimination, the way it sees the treaty obligation.
Jamil,
So,
you're making my case for me. Yes, the international community and the world community, and I always say this with a deep voice, international law, is almost in consensus that they don't like the death penalty. They haven't liked it for a long time. Most of our friends in Europe have abolished it. Other countries have abolished it. So there is a theme going through the UN in all of its bodies that it is against the death penalty. This is just one more vehicle to make that case. And Jamil, I'll assume for the moment that you don't know that you haven't been following ABA, but it is one of the most liberal institutions in the country. They have been against the death penalty for years. So their citation to the ABA in this document is of no consequence, as far as I'm concerned. So that's my direct response on that. And at the end of the day, it's up for the people of this country to decide whether they think the death penalty is cruel and unusual, whether they think it should be allowed. And we'll continue to have that debate here. But I don't need people from Egypt and Algeria to tell me that we should get rid of the death penalty here.
What? Yes. I mean, looking at this from an entirely different perspective, and you can put whatever label you want on that perspective, I think what this process does is ask our country to look at what accounts for the disparity. You have a policy that it seems to be neutral on its face, yet in its effect, it has a disparate impact on minority populations. What is the cause of this? Can we just say, well, the country has spoken and this is the law of the land, and the effect that it has on minorities is just, what was the word I used? Correlation and not causation, and that is the end of the discussion. I think when we get the recommendations and the conclusions from committees like these, and as we've talked about, this is an instrument that we signed on to, then it behooves us to come back and look at our society, looking at, even if we disagree with the countries or the standards of the countries who are giving us this perspective, it is a perspective that asks us to look underneath what our laws are and the effect that it has on our people. And this is not something that I think we should shy away from. I think it's something that we should embrace. I think we as a society have the ability, we've shown that time and time again throughout our history, to look very strongly and harshly at the effect of our laws and where applicable and where possible to change those. And so we basically need to ask ourselves, what has our constitutional tradition left us with? Has it been entirely effective? These cases that have gone up and down, the Supreme Court and back, have they been entirely effective in addressing the problems within our society, the problems facing minorities? We have a Fair Housing Act. Yes, we have rampant segregation. We have for example, going to what I know best, the Voting Rights Act. We have Section 2 of the Voting Rights Act, which denies dilution under our laws, and yet we have a Felon Disenfranchisement Act that allows dilution of the African American vote. What is our obligation to deal with that? And this invites this discussion that we're having here. You know, we talked about having a domestic discussion, inviting discussion of the impact on race in our society, and this just provides one more vehicle for us to have that discussion and to look harshly at the problems that we have within our society.
No, I agree with most of what you've said, and I think it does give one more vehicle. I mean, the fact that we're all here talking about it today is a consequence of our participation in the treaty and the report itself. So it does provide a vehicle to open the issues for discussion. I just wish that the committee would give more, I'd say, more constructive recommendations. I mean, the fact that more minorities are incarcerated above their rate of population in the U.S. is most likely because of lack of economic opportunity, living in areas where there is a depressed economic situation, other socioeconomic factors. But I don't think that the committee goes into those issues. Those are the real underlying issues about crime and punishment in America, but their recommendations just aren't very adult. It's end the death penalty, make sure that there's no racial discrimination in our justice system, which we should do, but digging in a little bit deeper, and it's one of the problems of the committee. They're not Americans. They don't live here. They don't study here. They don't work here, and to get down to the root causes of why people commit crime and are therefore overrepresented in our criminal justice system are the real solutions here. And I just don't know if the committee is the right vehicle to get to those root causes.
Just very briefly, just maybe a slight corrective in terms of the information that the committee has access to. That information is provided by Americans, for the most part. And those of us who were involved in writing the Charlotte report, I think we delve pretty deeply into these issues and provided the committee the kind of context that they needed to make a critical examination of U.S. practice. So I would invite everyone to of course, get Steve's paper, but also get the Charlotte report that was put out by the Lawyers Committee and ACLU, and the 600 or 700 page compilation of reports that were produced by the organizations as part of the U.S. Human Rights Network, and take a look at it, because they're broken down. And I think that you would be surprised at the range of issues that were raised. We have some critical issues here in this country that we really have to get serious about. And so it's not the committee that's basically making these comments. They made the comments, but of course, they made comments based on information that they received from, of course, the official U.S. report, but also from the reports coming from U.S. civil society. So again, if we are somewhat embarrassed by what has been surfaced, then it's just a reflection of what we need to do to address some of these persistent problems here in this country. Look, I have an agenda. I'm a human rights defender. I want the U.S. to bring its policies and practices in line with international human rights standards. I think that we can no longer pretend or play with the notion of American exceptionalism. I think it's very clear that we have some issues and problems here that we need to address. And that as a consequence, we have opened up ourselves for critical scrutiny and critical comment. And that's just the reality. So we can't fall back into some posture that says, well, no one can comment on our contradictions. Well, that's not adult. You know, what the adult thing to do is to begin to seriously address some of these internal contradictions. So my agenda, be it, I don't know, leftist or whatever, my agenda basically is to bring about that kind of accountability. I think it's a sad situation we find ourselves in, where we are in fact open to this kind of criticism, that we have to have people to talk about how barbaric and backward it is to imprison 13, 14, 15-year-old children for the rest of their natural lives. No one else does that. That is backward. We don't need a committee to say that. I'm saying that, and I'm from the U.S. So is that a leftist position or rightist position? I don't know. I think it's a moral position. That how can you throw away a human being, no matter how terrible the crime they may have committed, when they're a child, and say basically that child deserves to stay in prison death by incarceration for the rest of their natural lives. I can't be a part of that. I can't be part of a process in which you take someone who was clearly mentally ill when they committed a crime and basically say that you're going to pump them with chemicals, with medication, in order for them to be sane enough to stand trial, in order for them to receive the death penalty. See, these are the kind of things that our friends and allies around the world look at us and say, what is happening here in this country? What is happening here? You know, how do you explain those kinds of behaviors to any rational human being? The kind of punitive environment we have here in this country. That's not what we should be standing up for. So those kinds of things are reflected in this report. The kind of terrorism that communities are undergoing now, our Latino communities, as the consequence of these ICE raids across the country, where families are being torn apart, women are being picked up at work, and they have the kids at home in daycare, and they can't even make a call back to the caregivers to tell them, we're being deported. Somebody look out for my baby. Is that American? Is that what we stand for? But that's happening. So if these things are happening and we're embarrassed about it, so be it. We need to do something about it.
Okie dokie. Well, my last question, and then we're going to open it up after folks respond to this, but I was going to say, Steve, I'm signing you up for the lobbying efforts to get the country to ratify the Covenant on Economic, Social, and Cultural Rights. If I heard you correctly, right? The underlying causes of the contemporary manifestations of what some of us might call racial discrimination are economic in nature. So this may be a space.
I've just been fired.
Well, you know something? This may be a space where we can, in fact, talk across the divide, as it were, and move in a direction that benefits us all.
We can debate free market economics at another panel.
That's a whole different, I was going to say, other than being a lawyer, I'm an economist by training, so we can have that conversation. But my last my last question is, what, if any, role should Congress play beyond Senate ratification of treaties such as CERD? Hence, why are we here, right? We could have had this briefing just about any place else and not asked that last question, but we're going to take advantage of our audience. And are there specific issues raised in the committee's concluding observations from February or March that provide a basis for congressional action as far as the panelists are concerned? And I will just tilt that way.
I think there is much for Congress to do, especially that when we talk about implementation and enforcement, it is really up to the government, to all bodies of government, and mainly Congress, to exercise their power, and that is, to pass legislation that would bring the U.S. into compliance with the treaty obligations. And there's certainly some things that are already in the works. We're not talking about, devising or creating new pieces of legislation, and I want to mention a couple of them. One example is the ERPA, the End Racial Profiling Act. It's been in Congress for 10 years now or so, the bill that basically is trying to abolish and combat racial discrimination, mandating data collection regarding the use of racial profiling. And that is one thing that the U.S. can do by Congress, finally pass this legislation and do more to continue to monitor that those laws are being, of course, implemented and enforced. The committee looked at issues of racial profiling, and in fact, it asked the government to report back within 12 months. So the U.S. government will be preparing another small report, and one of the issues that will be in the report is what has happened with regard to racial profiling, broadly speaking, but particularly after 9/11. And the other area that has been also an act that was a bill that was particularly mentioned by the committee was the Civil Rights Act, which was presented on the birthday anniversary of Martin Luther King by Senator Ted Kennedy, and it was, of course, endorsed by other members of Congress. And this Civil Rights Act would in a way, fix some of the problems in some of the areas of law where were affected, and particularly responding to areas of concern that were sounded by the Committee on Racial Discrimination with regard to discrimination in employment discrimination, with regard to the treatment of workers, and ending certain things that have been left basically out of protection as a result of some Supreme Court cases. And without going to further details, that this is just a couple of examples where to show that the Congress has the ability, and I think the obligation under even treaty to exercise that. Whenever the monitoring mechanism look at treaty obligations, they always ask, what has been done on the level of educating the public officials, elected public officials? What are the kind of work? And unfortunately, there's very minimum, if any at all, has been done to let Congress know about this. I always ask Bob Harris from the State Department, who's I think in the legal advisor office, in what way Congress is being briefed about those treaty obligations and in those briefings. And they come through the very general briefings that happen regularly, but without going into the details of what happens and what the committee found. And it's mainly happened in the Senate Foreign Relations Committee. And I think there is a role for Congress to do more in looking at not only treaty reporting, but more importantly, treaty enforcement and analysis of what are the areas that the U.S. has to improve in order to bring it to compliance with, again, a treaty that is the Supreme Law, part of the Supreme Law of the land, and without, making now an issue with what are the things that have been left out in terms of the reservations, declarations, and understandings that the U.S. entered when ratified the treaty. That's, I think, another discussion, which is more difficult discussion. Hopefully that would be different when we get to the level of considering ratifying other treaties.
And I would just add that the Congress also has oversight over the federal agencies, and I think when you're looking at what the agencies are doing to affect the effects of their policies and how those policies are adding to racial disparities among minorities, that's something to pay particular attention to. Are the agencies collecting statistical data on disparities that would give us more of an insight as to why the disparities are happening and how we can fix those disparities? And also, when you, with the oversight, looking at what are the underlying factors of disparities and asking those hard questions that will force the agencies to take a stronger look at their policies and the effect that their policies are having on minority communities.
I'd associate myself with that last part. At the end of the day, those are the hardest questions. The underlying causes for racism, racial discrimination, and the lack of more racial harmony. Those are difficult, if not impossible, to legislate. And you can't legislate morality. Being a racist is something that you feel in your heart and your head. You either have to have a come to Jesus moment, or you're going to continue the rest of your life having your narrow views about people of other creeds and ethnicities and colors. But Congress can have a good debate about a lot of the issues that are brought up in the report. To answer your question, they can debate whether or not the death penalty should continue, whether people who have committed felonies should have full voting rights restored to them. These are subjects that are ripe for debate. You can take these to the floor and debate them all the time. You can debate about whether you should give sentences of life without the possibility of parole to people who committed crimes under the age of 18. That's a subject for debate. But at the end of the day, I agree with you that it's difficult for them to legislate morality. That's going to be up to the American people. Will be up for civil society groups like yourselves, and like Heritage, and like other groups that are out in the communities trying to get more understanding between different races and ethnicities, and especially in the post 9/11 world, between people of different religions. So I'll stop there.
And I agree with Steve that we cannot legislate morality, and that racism is something that is in fact in people's hearts, but it's also a little bit more than that too. It's also in structures and institutions, and that's why it's important for us to have mechanisms in place to monitor our social institutions, our legal institutions, our political institutions, and make sure that folks who are being subjected to certain kinds of behaviors, policies that seem on the surface to be racially neutral are not being detrimentally impacted. So I would say that some of the recommendations we would like to see implement would be to adopt specific implementing legislation for CERD and for all of the other treaties that the U.S. has ratified. We should develop a federal level system for monitoring compliance with CERD and the other treaties that the U.S. has ratified. We should fully fund and staff the Policy Coordinating Committee, which is a committee that is supposed to be involved in helping to monitor and respond to U.S. treaty obligations. Of course, we should have a system for ensuring that the concluding observations from CERD and other treaty monitoring bodies are adhered to. We should develop a comprehensive plan to encourage compliance with CERD and other treaty obligations on the state and local level. So these are some of the things that can be done by Congress. I think that the main thing we need to try to encourage is the creation of some type of national coordinating body, some type of national monitoring body. The notion of just a body that's committed just to civil rights is now obsolete. In the 21st century, again, we've got to be incorporating these human rights provisions in our domestic law and practice.
All righty then. So you've listened to mostly them talk for, about the past hour and a half. So at this point, we're opening it up. There's a mic there. There's a mic right there. Everybody who wishes to speak, I encourage you to queue up in an orderly fashion. Well, hey.
Well, hey.
How are you?
I just rode into town. Howard Wooldridge from Law Enforcement Against Prohibition. I'm a retired police detective from Fort Worth. Touching upon, follow-up on Jamil's point and Stephen's point, the racial profiling bill perhaps being considered by Congress, and the fact that the racist behavior is ingrained and you either figure it out or you don't. As a police officer, I'm fully aware of the racism in my profession. The difference is, given a badge, a gun, and handcuffs, racist cops are able to start this whole process going by arresting people. And as much as the racial profiling bill would be a positive step, further upstream, you've got the original cancer on so much that brings us here today, which has been the 37-year running war on drugs, which, as we all know, is a war on people, mostly people of color. If we were wise, as our grandparents were in 1933, to end this modern prohibition, has anyone taken a professional judgment or estimate as to the sheer number of cases we would not have that brought us here today in terms of 14-year-olds shooting 14-year-olds, then being sentenced to life behind bars, etc., if we took away this hook? Because what the drug war is a hook for racist cops to hurt people of color.
No, I do. I mean, yeah, I think that would go a long way in terms of some of the wars that are going on in various urban environments and rural environments. And we do know that a vast majority of the individuals who end up incarcerated are incarcerated as a consequence of drug charges. So it would have a significant impact on the rate of incarceration. But I don't have those specific numbers.
I'd only say that racial profiling was one of the items that were brought up in the committee report that I think is completely relevant to bring up. There should be a debate over racial profiling in Congress and in the executive branch, and so that was something completely legitimate, I think, for to be brought up in the CERD report. As far as legalization of drugs, I'll remain mute. Mute.
I just want to briefly mention that one of the areas that the committee looked at, and I think they're in the room, there are experts that are better to talk about this, is, you know, the whole issues of the crack cocaine disparities in the sentencing and how this is affecting particularly African Americans. That is a clear example where CERD, the government is, the United States is in violation of CERD, because there is a clear numbers. I think the Sentencing Project came up with a report just a few days ago making the same point and making it clear that according to the numbers, look how, or the numbers of people who are using crack cocaine among white vis-a-vis African Americans, and how the disparities in their sentencing. And so that is something that should be looked at, and I think the notion of wars, back to Jamal's war, the committee looked at the context of, or the consequences of the war on drugs, but also looked at, you know, the war on terror, and how this notion that you can launch a war on this particular entity that is not well defined, and how what happens is that you end up targeting communities and populations, not because there are, you know, reasonable suspicions to believe that there's some wrongdoing happened, but rather because of their color or because of their national belonging. And that is certainly an issue that could, not only for the legislature, I mean, Congress can do a lot, but I think it's a matter for the government of enforcement. And the area of selective enforcement is also significant. You know, where do you do the policing? How do you do the policing? And in what area, what neighborhoods? The resources and the now we see the raids and the racial profiling that's happening on the U.S.-Mexico border. That is all connected, and it's all, again, when we talk about intersectionality and why it is important to look at this particular human rights instrument, is because it does look at the full picture, and it does try to provide some, at least, you know, answers and recommendations where things could get better if the government will take its responsibilities more seriously.
Yes, my first question is an easy one for Mr. Groves. Given the Supreme Court's interpretation of the Vienna Convention in like Medellin versus Texas, and of our extradition treaty with Mexico and Alvarez Machain, what do you think the chances are that anyone will actually ever be able to assert their rights under CERD individually? And then I actually have a follow-up question, too.
Well, that one's easier than you might think. I believe that there is a portion of the convention that you can accede to if you choose to, where there's direct reporting of incidents of racial discrimination. You can go through a particular process where you report it to the committee, and then you have to engage in dialogue with the state party. And it's my understanding that the United States decided at the time of either signing or ratification that it did not.
There are two things.
Okay, I'll let Jamil answer that one more completely. Was the follow-up for me too?
Well, I thought that was the friendly one. The follow-up one is that in Connecticut versus Teal, the Supreme Court said essentially that, you know, Title VII, disparate impact, it's perfectly okay. Professor Crooms mentioned Washington v. Davis. That's an equal protection analysis, but we also know from like Huntington, NAACP versus Huntington, that under Title VIII of the 64 Act, you can have disparate impact as well. So if we did have implementing legislation, isn't it possible that people could, you know, bring a successful claim of disparate impact discrimination related to CERD somehow?
Of course, if you want to argue and have a debate on the floor about instituting a program, legislating an ability to bring a claim for disparate impact, that's a debate that should be had. I mean, that gets to the root of one of the major disagreements between the United States and the committee over what is and what is not racial discrimination. And I think that's a debate that should be had on the floor, by all means.
The process in the CERD convention related to individual communications or individual complaints brought to the attention of the committee is called early warning procedure, where basically the committee has the jurisdiction, and the U.S. has accepted this jurisdiction or this mandate for the committee to review particular cases or incidents where the committee believes that there is a serious or systemic violation or a pattern of violations of the convention that repeats itself. And those cases are very, very strictly selected by the committee. I think it reviews 1 or 2 cases in kind of on the merits every year. And there was so far, I think, one case that was reviewed from the U.S. regarding the rights of Western Shoshone Nation. That has been received international attention, and the committee had addressed this issue again in Geneva last time we were there, and found that the government has not been able to implement that decision. It's a long story, but there was some kind of settlement offered to some members of the Western Shoshone for violations of their land rights because of the way that their land was used by the U.S. government, and that was not satisfactory for the committee, and so it noted that in the recommendations. So there is a way that you can bring individual cases, but very rarely that they are taking every single case. It has to be really well documented that it's a case of pattern and a systemic violations of the CERD convention itself.
All right, can I just see, show of hands. Come on. Show of hands, people are queued up for questions. 1, 2. Oh, all right.
Hi, my name is Michelle Roberts. I'm with Advocates for Environmental Human Rights, and this is a very good week for me to ask the question that I'd like to ask. Earlier this week, we heard President Bush's wife condemn the Burmese government for their lack of response to the cyclone issue. So in July of 2006, the United States government was asked about their response to Hurricanes Katrina and Rita and the Gulf Coast. And then again in the CERD process in February of 2007, right? I mean, 2008, they were asked again their response to the housing issue with respect to Hurricanes Katrina and Rita. Each time the government was given a year to respond, and we're waiting for the response. So my question is, how do we, or how could Congress, is there a way that we can ask Congress to help get the government to respond? I don't know if you can answer that question for me, Mr. Groves, given, the Heritage Foundation really has their own opinion, but you might be able to help us out with that.
Well, officially, the Heritage Foundation is anti-hurricane. But I mean, obviously, all the state, local, and federal response to Hurricane Rita and Katrina were awful. I was actually in the Senate working for Senator Coleman when on his committee staff when it happened, and followed closely the report of Homeland Security and Government Affairs. I don't know I've been out of that game for a bit though, so I don't know what Congress can do more of. I mean, they can only push the executive branch so far, right? I don't know what Congress has been doing since the Dems took over in September, if they've been able to accelerate things or whether they're prioritizing that. But I hope that it gets prioritized for all the folks down in Louisiana.
She was before me. My question is also for Mr. Groves. a lot of your criticism of the process seems to focus on the committee itself, on the CERD committee, and I just wanted to mention 3 things about them and ask you if that would change your opinion in any way of their process. They not only critiqued the U.S. and made certain recommendations about what the U.S. could change, but as you know, that they had several constructive pieces in their concluding observations, including the passage, they noted the passage of the Violence Against Women Act and also the unanimous reauthorization of the Voting Rights Act. So, you say they are partisan, they are leftist, but there was a unanimous passage of the VRA. So one is that they do cite positive measures, and they mean them. The other is, you talked a fair amount about the composition of the committee and how these are sort of people who come from certain countries that don't observe the same kinds of rights that this country has in place, and that they therefore are not in a position to pass judgment on issues here. What you have here are 18 people from different countries. They bring together a wealth of experience. They have viewed and reviewed the race policies and implementation of those policies in myriad countries, highly democratic, middling democratic, and lesser democratic nations, and some non-democratic nations who are signatories to UN human rights treaties. So they bring a very broad compass to their view. Their job is to study the root causes of issues. And that is what I think that they do, and to propose recommendations to rectify those issues. Finally, you critique them in the way that they address issues. For example, you say they say end the death penalty, and you cited as one reason why that would be a somewhat useless recommendation, that 68% of Americans are in favor of the death penalty. Well, are statistics always the guide for policy? If so, what about the statistics on racial disparities, for example, in the criminal justice system and in the implementation of policies? Ought they not to equally be our guides? So that's what the committee, my view is, the committee is saying exactly that. They're not ignoring U.S. public opinion. They are looking at it. They are looking at the full amount of information they have before them on the death penalty, and therefore issuing the recommendation they believe is the most prudent. So I look forward to your answer.
I'll try my best. Those are a wide range of questions. It's easy. I mean, they've at the beginning of the report, they list some things that the state party has done, including reauthorization of the Violence Against Women Act and the Voting Rights Act. I'd never call those leftist. Those are mainstream pieces of legislation. At least today, in the 21st century, they may have been considered leftist back when they were passed by some people in this country, but I'd consider them fairly mainstream. So the fact that they're giving us kudos for reauthorizing our own, key human rights legislation is all well and good. They can give us a pat on the back for that. As far as the committee itself, although they bring a wide range of viewpoints, my key problem with it is that this is an issue that we struggle with here in our country, and every person in this room has experienced or seen racial discrimination or bias or heard awful hate speech, and we all deal with it in our own way with our families and our friends and our communities and our places of work. It's something that's interwoven throughout our society, and it's something that we need to deal with on our own. I just don't know how credible the observations, however wide-ranging they are, from Togo and Pakistan and Greece or Denmark or everyone else, is going to be able to inform us how best to proceed with these problems that are so deeply ingrained in our history and tradition. I mean, the problem of racism is fairly worldwide, but each country has its own history that it has to deal with in its own specific way. And I just, everyone here can read the report for themselves and see if this is a credible path for achieving what we want to achieve in this country. And finally, as far as stats guiding policy, I would, if you watch the floor of either the House or the Senate, statistics are used fairly widely in making policy choices one way or the other. And the fact that the UN system in general has for a long time had had its own policy and its own feelings about the death penalty, doesn't mean that they should just continue to recommend that states' parties should prohibit it. That's, again, something for us to decide as a people. And anti-death penalty activists have long been at it in this country. They're well represented. But the latest poll, this was in February, I think, was 68%. It was a poll that really confused and bewildered the anti-death penalty community. And I'm not saying that I'm a pro-death penalty guy. I'm not, line them up and shoot them. But the facts are the facts, and Americans need to make choices whether they think that's the right way that this country should go. I think in time, maybe when we become all enlightened here in this country, we'll get rid of the death penalty. But that's for us to decide. Thanks for your questions, though.
Okay, so final two questions are lined up on the right, my right, your left. So.
Hi, everyone. In coming here today, I couldn't help but think of the Sean Bell verdict that happened 2 weeks ago, where 3 officers were acquitted of gunning down Sean Bell and, killing him and seriously wounding and injuring his friends in the car. And thinking about that and thinking about CERD, I was just wondering, the unique circumstance of this case is that 2 of the officers were black. And so in trying to apply CERD to this case where I guess an instance or a scenario of racial discrimination isn't really clear, how do you apply CERD to such a case or such an instance? Anyone, to anyone.
I'd say that's a very good question. But I think what we've been talking about today is looking at the policies and not just the actors who carried out a particular act, but what the policies that were in place that made these gentlemen seem as suspects because of what they look like, where they are, the neighborhood, and that sort of thing. So it's hard to say for that particular circumstance, but it just gets back to the point that we really need to look at how the underlying effects of our policies have on minority communities, despite who, within the community is carrying out the act that specifically impacts the minority community.
I just want to mention in that I think in regard to, situation like the tragic killing of Sean Bell, is that, and this is what this committee and this convention is all about, is not only looking at individual, act and activities of individuals, but rather looking at institutional and structural paradigms and how the system is set up to treat everybody fair and in balanced way, like Fox News, the fair and balanced. And that is really about the issue of whether we want to, if we look at the identity, the color of the people who committed certain crime, whether they are, in the fact that they belong to certain community does not mean that, that there's no problem with the act itself. And I think that it really goes beyond that to look at the issues of structures and the way that the government is functioning in those situations. And the committee in particular looked at this issue and there's between the lines you can read it, is that it really asked the U.S. government to take more actions in order to the language, I'm trying to find the right line, including to do more, including studies and to determine the nature and scope of the problem of racial discrimination, the implementation of national strategies or plans of action aimed at the elimination of structural racial discrimination. I think that is a significant thing that we have to look at, and it really helps us to see whether it's only individual isolated incidents of discrimination that we're talking about, or there's more beyond that. There's a much significant and important structure that is feeding and is leading to those results.
For me, it falls into the realm of police brutality, and it's an issue that's properly brought up in this committee, and I believe it was commented on in the report about how there is a history of police brutality against minorities in this country. The fact that in this particular case there have 2 of the 3 officers happen to be black doesn't mean that the police were any less brutal. So it's a proper subject for debate under the CERD report, police brutality.
I'll wrap it up. You're in. I'm in.
Catherine Powell, I'm a professor at Fordham Law School. I want to thank the panel. Your comments have been excellent, and I want to pick up where you left off, which is what role can Congress play specifically? Beyond specific pieces of legislation that can be passed, we know that the executive branch under Clinton had an interagency working group, which, as I understand, is now defunct, and Congress has oversight under the Foreign Relations Committee and the Judiciary Committee, the new Human Rights Committee. But these issues of human rights compliance, CERD and other treaties in the U.S. don't seem to fall within the jurisdiction of either of those committees. So I wonder if the jurisdiction of those committees, if you might recommend they be expanded. Should we look to the UK? The Parliament there has a committee that reviews each piece of legislation for compliance with the European Convention on Human Rights. Might our existing congressional committees look to that model or other models, or should Congress create a new committee that can look at human rights compliance in the U.S.?
Well, I mean, folks who are here are also know better about the fact that there are not only the Senate Foreign Relations Committee and the Judiciary Committee, but also some of the subcommittees have jurisdiction in looking at some of the issues that were raised by CERD and other treaties, so that you do have a way to analyze and look at them and ask the government to come with reports about how what has been done in this area. But more recently, we know that there is a subcommittee on human rights and the law. I think it's Senator Durbin heads this committee. And it looked at some of the human rights issues, but I think until now it was more in the extraterritorial level, looking at the issues of like renditions, and it looked at the issues of trafficking. But we're hoping that this committee and other subcommittees or general committees will have the ability to look at that. Other thing I want to mention is that's really interesting, was used and utilized in the last few years, is the CRS, the Congress Report Service, is the research service, which produced significant amount of analysis of U.S. compliance with, for example, the Convention Against Torture in the context of treatment of detainees and prisoners. It looked at issues of renditions and compliance. It even looked at the possibility of ratification of CEDAW, the Convention on Elimination of All Forms of Discrimination Against Women. And I think that would be another way for Congress to utilize that and see how CERD is being implemented, what are the other ways could be, and looking at other models, comparative models, would really inform us in how best to proceed on this, whether from the UK or other countries. Canada has some good models on that. Some other federal governments, I think that's a very important look at, governments like Australia and New Zealand, and how they dealt with a situation where they have local governments, with more powers to the state and local level, and how do you really reconcile that, and when it comes to international obligations.
But in case Congress can't get its act together, if there's a possibility of a friendlier administration in terms of human rights, we have examples of when the executive has taken the lead. 13107, of course, was the order that established the interagency working group. So there's a model in which the executive might take the lead in establishing a coordinating body that will take up some of the work that was started under the Clinton administration. We understand that was abolished by the Bush administration, and its duties and were transferred to a policy coordinating committee that it was, I think, reporting to the assistance to the National Security Advisor or something. But there's some models in which the executive can take the lead in terms of the kind of body we need to really help coordinate compliance.
Okay, moderator, correct.
2 seconds. Sorry? Okay, I'm Hadar Harris. I'm with American University Washington College of Law. Just 2 quick points. There's been a lot of discussion about the membership of the Oversight Committee for CERD, people that come from Pakistan, from Egypt, from Algeria. It should be noted that these people are elected as independent experts. They are not governmental representatives. And so whereas the point has been made repeatedly that these people may come from a culture or a government that does not adhere to many of the human rights standards that one would hope would be promoted. These people are elected to these positions of oversight on the basis of their expertise, of their independence, and not being representatives of their own governments. And so I think it's an important clarification, an important point to be made. The other comment that I have is that much of the discussion seemed to me, or I guess one of the comments that Mr. Groves made, seemed to reek to me of things that I heard when I was executive director of the Congressional Human Rights Caucus up here on the Hill, which was when we would send a letter out to a government like the Soviet Union back in those days and said, you know, we're very concerned about the civil and political rights of certain groups of people within the country. They would send letters back and say, you're meddling in our internal affairs. And much of the critique of certain countries is that the human rights regime enables people or promotes the meddling of internal affairs. And much of what I heard from Mr. Groves, with all due respect, seemed to very much echo this, that these international bodies shouldn't be meddling in our internal affairs here in the United States. But we live in a globalized world today, and human rights is a globalized concept today. We have ratified 3 basic human rights treaties that hundreds of other countries in the world have also ratified. And so it's not that these bodies are meddling in our internal affairs. We have invited them, as members of the panel have noted, to take a stand, to help us consider how we can better comply with the obligations that we have voluntarily adopted. So I just wanted to be sure to make that point and to hope that we have moved beyond this kind of critique of you're meddling in our internal affairs, and instead to say you are invited to help us better comply with our universal human rights obligations. So, and thank you to the panel. It's been a great discussion.
Hold on. Just one moment. First of all, unless someone corrects me, although members are elected by their peers that are also involved in the committee, the slate of candidates is put forward by the country itself. Pakistan chooses which candidates can sit for its seat.
State parties, the parties who are, the countries who are members and parties to the treaty are eligible to both be elected onto the committee and to put forward candidates for election.
Well,
but they're go ahead.
The state party that puts forward the slate of candidates are the candidates that eventually get elected.
I'm sorry?
Pakistan
could put a nominee into contention,
yes,
but they are not awarded a slot automatically onto the committee. They're voted onto the committee by the rest of. Yeah, I mean,
I don't think that's how it works. Especially when you're dividing the panel by geographical representation. You know just how people are elected onto the Human Rights Council. You follow these elections where the slates are put forward.
Yeah, but those are governmental representatives. These are independent experts.
But they've still put forward the experts. And if anyone wants to reconvene, we'll do analysis of the 18 people that are on this panel. I'll be happy to do it and find out exactly how they came to hold their positions. Or unless you have that analysis done already, I'd be happy to read it. In terms of comparing what the USSR did during when it was around and what we're doing, I don't think you can compare the two. And I've never said don't meddle in our affairs, because I know that by signing on to this treaty, we invited other countries to comment on our affairs, and that's the whole danger, and that's why we need to stay away from some of these other treaties like CEDAW and CRC and indigenous people and whatever the other treaties are that will allow committees such as these to use your words, meddle in our affairs, not mine. I think is dangerous. I think this CERD treaty is kind of the canary in the coal mine. As long as we democratically, through our president and our Senate, decide that we're going to be party to a treaty, that's fine. Let's have that debate. I would just submit that my position would be to avoid those types of situations. But thank you for your questions.
And now on that note, thank you for coming. Thanks to ACS for putting this together. And thank you for giving us an extra 7 minutes of your time. Enjoy your weekend. And